Hi, I'm Henry Quillian. I'm here at Taylor English with all my colleagues in the litigation department. This is Litigation Fundamentals with Henry Quillian at Taylor English Duma. And what we're going to talk about today is sort of analyzing, going through a contingency fee agreement that I ran across and looking at all the terms that would be terms you would want to consider in connection with any contingency fee agreement you're into relating to litigation. This one's sort of loaded up, for lack of a better description, and the claims that it's associated with are sort of loaded up such that if you take the agreement on its face and presume a successful outcome in the litigation on its face, you can end up with sort of extraordinary results for the lawyer and law firm. So I thought it was good to look at these because it really does almost within it have a checklist of all sorts of things you would want to consider when you're entering into a contingency fee arrangement. For those out there in the world, this is really just an analysis of terms for you to take a look at when entering into a contingency fee relationship if you're a lawyer. On the flip side, if you're a client, you might want to look at the terms that your contingency fee lawyer is putting in front of you and consider, if it's a very significant matter, getting a lawyer to help you in negotiating that arrangement, because it can make a huge difference. As a matter of fact, in this sample agreement, which of course I sanitized, this is from a situation, you will see that it says it is imperative that you receive independent legal counsel to advise you before signing this agreement. So, and essentially what you're doing is you're going to a lawyer, so you have to get a lawyer to go to the lawyer. And to get yourself signed up for this engagement. And there are risks that we will talk about for the client within the context of this engagement agreement that the client would want to be aware of before they are unhappily surprised down the road. So let me set up the underlying subject matter, and it's going to be fairly straightforward, but reasonably complicated because we all are smart people and like complicated things. We're contemplating a state False Claims Act case. We're assuming it's going to be successful at the end of the day, and that the total claim established by the state against the defendant will be $10 million. In connection with that, the law firm that's getting this engagement will have accrued $400,000 worth of hourly accrued time associated with their lawyers at whatever reasonable rates they have put in there, and that the costs, which are defined in this agreement, will have totaled $200,000. In connection with this False Claims Act case, which is a direct action that is brought by somebody called a relator, somebody who is a whistleblower, on behalf of the state against the defendant, that person also happened to be fired in connection with blowing the whistle on the employer, and that person lost $400,000 in wages, and during the course of the litigation, the lawyers allocated $100,000 worth of hourly accrued time to winning the case for the lost wages. Now, I'll point out, this is not the lost wages damage award, this is the wages that were actually lost. And of course, I think probably just about every state has a False Claims Act statute. They're likely to be different, and various states have different provisions, etc. But in this state, for instance, the theoretical state we're talking about, it allows treble damages on the actual losses to the state against the defendant. So in theory, the actual loss to the state was $3.33 million. And it also allows double recovery for the lost wages to the injured party who was fired because of blowing the whistle on the employer. So, as we'll talk about later, at the end of the day, we would end up with a $800,000 damage award associated with these lost wages. So, we've got pretty big numbers, not ridiculously high numbers, and the client does not want to pay $500,000 plus $200,000, $700,000 out of pocket in order to pursue this action. And this is sort of an aside, but the hope is by the lawyers that the state Attorney General's office will ultimately take over the False Claims Act litigation and pursue it to the end. And that impacts not the fee agreement, but it impacts who has to do how much work, basically. The other thing I'll point out is that the law firm would typically advance these costs associated with the case, and that's what's contemplated in this agreement. So we have a situation here where the client wants to bring this action. They think they're going to make a good relator, and the relator will sort of have certain rights in the recovery that's ultimately obtained by the state. We're going to assume for the moment that is and it's on the high end of the spectrum, especially if the state takes over the pursuit of the litigation, that'll be a 25% of the total to the state recovery, which means to the benefit of the relator, i.e. the client in this matter, that would be $2.5 million. So, the client walks in, agreement is given to the client. The agreement says you better go get independent legal counsel. Typical client, I would say 85% of them is say, where do I sign? Maybe not even read the agreement. Let's hope they read the agreement, but typical client, where do I sign?
Henry, question. If you know they have not seen independent counsel and you witness them sign it, is there any issue? Because you have knowledge that they didn't actually go get independent counsel, but they warranted that they have.
Okay, so the question is, if as a lawyer, you have this thing saying, I warranted that I got independent counsel, but you handed them the agreement and 10 seconds later, they're signing it and there was no independent counsel present in the room with them, what does that give rise to ethical problems? I would say yes. I think that, and what I sort of wanted to add as a disclaimer is, I don't want to try to get into all the ethical issues that this type of setup could lead to, because they are numerous. But to me, if you're the lawyer and you take the agreement, especially if you go down, there's an affirmation, a warranty that they've had the opportunity to and have sought independent counsel. I don't see how you can take it the next day. I think you have to say, go get your lawyer and come back to me tomorrow morning at the very littlest. Otherwise, you're going to have a known falsity sort of baked into the whole scenario.
Henry?
Yes.
Do you have to give does the individual actually have to seek independent counsel, or is it sufficient that you've given a reasonable opportunity to do so?
Yeah, we're advised.
I have to say it has to be the latter. It has to be the person has a reasonable opportunity to.
Well, why don't we include in the draft letter then a representation that the individual has in fact sought legal counsel?
Oh, well, this is a letter that was put on my desk. This isn't a letter I drafted.
Okay.
And I also will say this is a letter that I have seen, the substance of which I have seen a number of times. I guess I'll put it that way. So therefore, it gives rise to all these questions. And I think as a law firm entering into a corporate type relationship, a commercial relationship, you want affirmative statements like that from the person that's signing it, so that you can say, well, we told them to get counsel. They said they got counsel. How are we to know they didn't get counsel? All right. But like Todd was saying, if it's a hand them the document and they sign type situation, and it actually says I did get legal counsel, that's a problem. And so I don't know. And that's subject matter for another day. In fact, I think we could probably do a whole seminar on the ethics of contingency fee agreements. But if you know they didn't get counsel, to have them sign an agreement saying they did, that seems to be not within the realm of what I think should be done by a lawyer. Okay, so in any whistleblower act, there could be criminal situations. In this situation, the attorney saying, "Hey, if you get called as a witness or whatever, we'll defend you, etc." And that not in a situation where you've actually been targeted, but we will help you out if you have to go testify, and that's in part, I would say, to protect their own interests in the contingency fee case that they have pending simultaneously. They talk about, here's a provision that virtually all fee agreements should have, which basically says if we're changing anything in this agreement, since it's a written agreement, it needs to be reflected in writing. And then it has the duties of the lawyer to zealously represent the client. And then, of course, it has the disclaimer, which lawyers love. As you know, there can be no guarantee of complete or even any success in any given matter or objective. Now, so we have a start date of representation. We have a description of what the representation is going to be. We're going to represent you in these claims. And then we have a start date for the representation, which will be the date that's filled in for the agreement. And then we have an end date, termination of the agreement, which we'll go over later, which is a really dicey area when you're talking about contingency fee cases. All right, so the lawyer says, I'm going to represent you in all this. I'm going to be your legal advocate. We don't know how much time it's going to take. It could take a ridiculous amount of time. It could take a little bit of time. We're going to use our paralegals. We're going to use other vendors and people that are providing services, and that you are asking them to do it on a contingent fee basis. And you have considered the risks involved in this case, as all lay people are well able to assess. And their experience and reputations, that goes to how much you might want to pay them on an hourly basis if they were to do it, and whether they're going to win or not, you think they're going to be good or not, you think they're going to be ethical or not, and the uncertainty of the number of hours necessary to prosecute the case. Now, here we get to the nut of this. So, how are the lawyers going to get paid? Well, as mentioned, in a False Claims Act case, if the gross amount of the recovery to the state is $10 million and you assume a 25% relator's portion of that, how much is 25% of $10 million? $2.5 million. So that would be a number from which, a number I'll point out, not necessarily the number, it depends on what the agreement says, from which a contingency fee, meaning the fee portion of the payment to a law firm, is calculated. In this instance, as you can see, they talk about 40% of the gross recovery and 100% of the attorney fee award. Now that's wonderful. That's a question. All right, so if you've got a contingency fee for work and then you have 100% of an attorney's fee award, what is that other element? All right, so under a False Claims Act, typically what would happen is, after winning, the lawyers would submit what's called a lodestar claim to the court for consideration. That consideration would be based on an assertion by the lawyers that their time accrued at a reasonable hourly rate, that they had to do this work, it was reasonable and necessary. It's very similar to a OCGA 13611 claim, where there's proof shown that they have their high competence, they're worth this amount of money, had all these associates working on it, etc. And so I just assumed a $400,000 accrued hourly for just the False Claims Act portion not associated with the employment claim. There's only one thing though. That attorney's fees award, as defined, also can include an award of the costs or expenses associated with litigation. But we'll see how that flows through this agreement. So this attorney's fees award also can be grossed up by the court. The court can, in its discretion, can grant either 2/3 of the, or any percentage lesser than one, of the award of the claim by the lawyers for attorney's fees, or if the court is particularly wowed by the lawyers and what a great job they've done, the court can give a multiple of the hourly accrued. So now we're talking about stacking of attorney's fees, 40% of the gross recovery plus 100% of the attorney's fees award. Something you'd want in every contingency fee agreement. What is the gross recovery? Here, interesting definition in that it says gross recovery means and encompasses any and all amounts and or things of value recovered in or because of the case, whether by settlement, judgment, or otherwise, and includes but is not limited to cash, real property, tangible and intangible personal property, whether payable to or deliverable to you, third parties, or us. It's hard to know. In this instance, does third parties mean the state? The state would be a third party as between the firm and the relator, but the state's going to be getting $7.5 million. So there's an ambiguity in this particular agreement from my perspective, especially if you're talking about bringing an action on behalf of the state. And I don't know who the other third parties might be, but I guess the future would tell. But does not include the attorney's fees award or the costs. Okay. So basically, if you're doing any contingency fee case, you got to contemplate all the different ways you might get paid at the end of the day. And I've certainly had contingency fee cases where somebody said, the defendant says, well, I don't have cash, but I'll give you my lake property or whatever as your part of your recovery. And if it's your lake property, as the lawyer, how do you value that from the standpoint of you and your client? This contingency fee agreement does not have an appraisal provision in it, but I've done that before in contingency fee agreements where I say if something other than cash is paid by the defendant, we will have you'll get an appraiser, I'll get an appraiser, then we'll have an umpire, and if we can't reach an agreement, or if you can't reach an agreement as to what the appraisal should be in order for calculating the fee, then we'll have a third person decide, and it'll be like an insurance claim appraisal where the amount that's attributable to for purposes of the contingency fee is calculated that way. And then somebody's may have to sell a piece of property in order to pay that fee. You don't know. It depends on how rich the person is you're dealing with. They don't know they can make it up in cash or not. And I certainly know lawyers, I personally know lawyers who have gotten cars, mountains, property on Northside Drive or on Riverside Drive as part of their contingency fee, as for a case they pursue. In fact, I know one lawyer, if you go on Northside Drive, the Tuxedo Elementary School, that was actually property that was part of a contingency fee one time. So you got to have some provision that captures all these things that you want to include as part of the base value from which you're going to calculate the contingency fee. You sort of hope that it's cash, but then again, it could be something else. I know that Eddie Garland, who my wife worked with, had a Mercedes and had a big chunk out of the bumper on the Mercedes, and that was part of a fee that he got, and it had gotten hit with a bullet or something. So they chopped out the part of the bumper because it needed to be used as evidence, but he got the car. That was a while back. Okay. So the attorney fee award means anything encompasses any and all amounts or other things of value recovered in or because of the case and resulting from the award or order or agreement or payment to pay legal fees, and includes but is not limited to cash, blah, 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 blah. But the term does not include gross recovery as defined in this section or costs. So, however, those costs are defined differently from the way the third party court might refer to as costs. But it's possible to get, like I said, an award from the court, from the defendant, made payable to the law firm that is on top of the gross recovery. Now, this is an important provision to have in any contingency fee agreement because it's possible that you're going to be getting your money at the end of the day in some sort of settlement over time, and so that gives rise to when do the lawyers get their money versus when does the client get their money. And the way they've set this up here is you figure out the total value of the structured payments over time, and then you apply a present value calculation. You identify how much that is at the time of the signing of the settlement or the entry of the judgment, and then you it says our fee will be paid out of the initial lump sum payment. If the payment is insufficient to pay the contingency fee in full, the balance will be paid from subsequent payments before any distribution to the client. So theoretically, if it's a long payout, the lawyers could get paid for years before the client gets a dime. And so the client will have some say in the overall setup of the settlement, but they would need to be able to do a lot of different calculations and a lot of different determinations, might need their own lawyer to represent them in connection with how they're going to do the settlement in order to avoid basically dying before they ever get anything, just leaving it to their children or whatever, depending on how big the fee is and whether and when the money's going to come in. There are lots of different ways you could do this in a typical contingency fee arrangement. You could have it so that the money is just split as the money comes in or as it's collected, or you could try to get it all up front as the law firm and then eventually have the client get the money. So, of course, it says if there is no gross recovery or attorney's fees award, we will receive no fee. And that is the risk that the law firm takes as a contingency fee lawyer. And, of course, that's what we all hope never happens to us. This is a very interesting provision. It says that you are, at the time of the determination of a gross recovery or the entry of an attorney's fee award, this amount is segregated off and it becomes the property of the law firm immediately. And we can go collect that even in the absence of your attempt to collect your portion of the recovery. And I can't quite figure out how they contemplated this being carried out, because if the law firm were to say, all right, we've got this huge judgment, bye client, we're going to collect our money, good luck with yours, that doesn't seem to be full and zealous representation of the client. But the way they have this set up is it's a separate and independent property right in the recovery, and it seems to me like there ought to be a proportionality or some commitment on behalf of the law firm to pursue recovery, and then that the money would be split on a pro rata basis depending on how the calculations come out, and also depending on whether, as we will see, whether costs have been recovered. Has anybody ever seen a provision like this where they try to segregate out the fee and say that's our property interest once it's determined what it is? And the only thing I could see why you'd want to do that if your client died or something and their estate said, I don't want to do this anymore, I don't want any interest in this, I never liked that case to start with, yet the law firm has won this huge award and they want to be able to pursue it. But I think we would need to look into the ethics of that, but if it is ethical, it's something to consider, because you don't want to have a right that you can't pursue if you've spent your life giving rise to that right. Okay, so one thing I have, and then we have the cost provision, which says we will incur various costs, expenses, and been providing the legal services, and costs are basically defined as all these payments to third parties, where we call them expenses in Georgia. It's court reporters, consultants, expert witnesses, couriers, legal research, etc. So let's take a second and talk about it under this scenario, how the money would play out for the law firm and the client. So out of $10 million, if we got a 40% contingency fee, that comes out to be $1 million fee. Everybody in agreement with that? So we would have $2.5 million minus $1 million So that $1 million goes over to here. That's the happy day for the lawyer. Leaving $1.5 million. Okay, but then you will see that there's a right for the firm. The firm will receive payment from you of the costs. Let's see, it's right here. This firm will receive payment from you of the costs immediately upon receipt by you or this firm of any portion of your gross recovery. And will do so by taking and receiving that portion, the full amount of the costs incurred to date. So, firm takes the costs. So that leaves $200,000 minus here, $1.3 million. So that's going to be a plus $200,000. And this is reimbursement for what they've already taken out of pocket. But they'll end up netting, well, grossing $1.2 million out of that settlement. But then, they may hire additional counsel. If they do, they'll be calculated just like they would if they were working for the firm. If there are disputes, then they'll be arbitrated. The state, and that's an important provision to have. We have one in our standard fee agreements, arbitration in the event of a dispute. However, as you can see, these people choose the American Arbitration Association, not the state bar. And that could be an important decision to make as to who's going to be the one to resolve fee disputes. Actually, it starts off with the state bar, and then if there are other disputes that are outside the scope of the engagement agreement, then they go to the American Arbitration Association. And that could be something, I suppose, like what's the value of the real property that has been obtained as part of the settlement that we can't decide on what it's worth. Now, as mentioned, however, what if the court enters an attorney's fees award as a result of what's called this lodestar submittal to the court? So in that instance, the law firm is going to say, well, we did a heck of a job on this matter. We spent $400,000 and we incurred $200,000 in costs. So the court might come back and say, well, yeah, you did such a good job. We're going to give you $800,000 for the $400,000 worth of work. Now, I've definitely seen it happen, reported in cases. So, and then also, you spent all this money on this, the court sort of assumes as if there is no recovery on a contingency fee basis by the lawyers. And so theoretically, the law firm could have another $800,000, which is twice their hourly rate, plus another $200,000 recovery, the way they have this thing set up, because they excluded the cost from the attorney's fees award and from the gross recovery, which could result in a total of $2.2 million. Really happy day if that happens and they collect it. But we also have this other claim that's based on essentially the exact same facts. And under that case, you can get, if you use this particular statute, you can get up to twice the lost wages, which would be $800,000. And so if they prove this, then they're almost certainly going to, if they're going to prove this, they have to prove this. But if they do prove this, very likely they're going to end up being able to prove the lost wages claim. So if they had the $800,000 in recovery, that would be minus $320,000 in fees. So that goes over this side. This is why people do contingency fee work. If it comes out well, it can come out really well. And then, which yields only $480,000 for the client. But since it's a lost wages claim, let's say they have a 40% tax load on that. So that would be to the federal government, $320,000, and it would be of the $800,000, I believe. And the state and Fed, so that would mean the client could end up out of all that with $160,000, but the lawyers could end up with $320,000 recovery on the contingency fee, and then they could end up with $100,000 on the hourly award, which is also provided for in the statute. So they could end up with $420,000 plus the $2.2 million for pursuing this case. Anything coming to anybody's mind concerning the outcome of this matter, both for the lawyers and for the client?
Henry, I have a different question though, as we're putting the numbers up. I want to know in practice, how does it work, not necessarily under this scenario, but if you get awarded punitive damages, and how does that work for necessarily for the attorney in Georgia? And this is kind of left field, but I was curious.
Well, I mean, I think a punitive damage award is for the attorney, from the attorney's perspective, is exactly like any other judgment you get. If you get it and collect it, then it calculates and flows through your contingency fee agreement just like any other money would. Anybody disagree with that? And that's what we all want, right? We want the claim that has $100,000 and then $15 million of, actually we don't want too big a multiple, or we'll litigate it forever. But we'd love to get maybe 3 or 4 times our actual damages, right? On punitive damages, so it won't be found to be unconstitutional. So it would flow through if you collect it. Now, we get to some really tricky aspects of this agreement. So, what happens if, however,
Henry,
yes.
you mentioned one thing first regarding the out-of-pocket costs.
Mm-hmm.
So the firm has to fund those, and they're treated as a loan for tax purposes. So you don't get a tax deduction for those expenditures until the case is settled. So depending upon the amount of investment involved, the firm has to invest after-tax dollars to fund those costs, and doesn't get a tax deduction.
All right, so are you stating that as a fact? Or are you just making a comment? Or how, I mean, just so that y'all can hear what he's saying is that when the firm does advance these costs, these expenses, then it's all with after-tax dollars from the perspective of the firm, and the tax ramifications of that can't be really addressed until a settlement. So, for instance, if you end up spending all that money and getting nothing, then you spent after-tax money that's out the door unless you can get it back from the client. Is that all right? So we're not giving legal tax advice, but that's an observation concerning this matter. But that does come up in connection with this termination provision. Now, lawyers want to be able to get out of a situation if they need to, and they also want to be protected if their client wants to skedaddle on them right as they're about to get a big recovery. So this document allows for the law firm, we may terminate this agreement at any time with or without cause, and we will notify you in writing of such termination. Cause for termination shall include failure by you to honor the terms of this agreement, or for any reason required under the Code of Professional Responsibility or the rules of courts of the United States or of the state of blank. All right, so you're the client. You're signing this agreement that you're engaging these people to pursue this matter for you with great zeal. You are possibly serving to them something on a golden platter that they're going to be able to make a whole bunch of money off of, maybe $2.62 million. And they say, well, but we can terminate this thing anytime we want to, for any reason we want to. And they give this reference to this incredibly unidentifiable set of rules and professional responsibilities that you have no idea what they are as the client, nor would you know how they were applying them, and how would you ever get a ruling on whether or not, if they terminated you out of the blue, whether or not they had done it for cause. Let's just say for the moment they find out that there's a conflict of interest with another client that they like better. And so they say, oh, we can't represent you anymore. All right, so now you're stuck. What are you stuck with? And that's for cause. And then they say, we can terminate you without cause. If they terminate you without cause, you, the client, agree to pay us for all the costs incurred through the date of such termination. Well, what if it was well into the litigation and $200,000 had already been spent? Under the terms of this agreement, the client has to ante up as soon as the lawyers decide that they are terminating the client without cause. All right, now, what happens if they terminate an agreement with cause? You agree to pay us at the time of recovery, whatever that means. I don't know how you're going to get the recovery without the lawyers unless you go get more lawyers. For all the services rendered by us at our normal hourly rates on the matters then pending, and for all the costs incurred through the date of termination. And then that sets forth the rates of the lawyers. Now, so who thinks the client is taking a risk when they sign this engagement agreement? All right, John does, Winnie does, Annette does, because they could say, we've got a rich client, we think this is going to be a loser case, we've spent all this money, let's just collect it back from the client. And under the terms of the agreement, they would have the right to send a letter saying, we have determined that we can terminate you with cause because we think there's a professional rule involved. We're not going to, and we're going to terminate, or we can terminate you without cause and get all our costs back. If they can come up with some professional rule or rule of court as an excuse, then they ultimately can recover all this hourly rate that they never, but only in the event, well, it actually says at the time of recovery. So the question is, when is their time of recovery? Also, it put the client in a huge burden, such a bad situation, because they would have to get a new law firm, and the new law firm would be, the case would be burdened by this expense of all these fees that have run up and costs. And you may have a very hard time getting a new law firm so as to get a recovery. Now, so that would be one reason for sure why a client would want to get a lawyer to negotiate this fee agreement. Now look at the opportunity of the client. You may terminate this agreement at any time with or without cause, and you agree to notify us in writing of such termination. In the event you terminate us with cause, you agree to pay us for all costs incurred through the date of commitment. So is that a deterrent to the client, if the case has been going for a while, to the client just terminating the lawyers out of the blue?
Yes.
And what if the client just says, well, I don't have a heart for this anymore. This has been going on for a decade, and now there's $1 million of costs run up. The client's wants to move to the other side of the country, but they're unable to do that because they're just having to stay around and hang out and support this case. That would be what the lawyers would want to prevent the client from doing, which is fair enough. And this is a big deterrent to them determining, I'm just going to back out of this and just say, forget it. And then, of course, if you, in the event you terminate us without cause, you agree to promptly pay us at the time of recovery our interest in and share of the gross recovery and attorney's fees award for all costs incurred through the date of termination. So, there are other provisions I've seen in contingency fee agreements that will excel. If the client decides to terminate, the law firm says they convert it into an hourly rate case, and the bill is sent to the client upon termination. So, things that you need to consider when you're entering into a contingency fee agreement is: do you make the contingency fee based on the gross amount that's brought in on behalf of the client, subtract the fees, and then subtract the costs from the from the client's recovery? Or do you subtract the costs first from the recovery and then calculate the contingency fee? I've seen it both ways. I think there are reasons for having it off the gross, because the client may say, keep spending, if they don't have the downside of having it ultimately taken out of their recovery. It seems to me like there has to be a determination of how many different ways the law firm can get paid. And if the law firm can get paid, especially costs, more than one time, both as part of the contingency fee and as part of the attorney's fees award, if I was the client, I would really only want to pay the costs one time. So I would say something like, if you get it awarded by the court and you recover from the defendant for the costs one time, I'm not going to pay them to you again. That seems to be fair enough to me. I suppose there could be an interest or something applied to those costs to make it completely balance out. But if I was a client, I wouldn't want to pay the cost twice. I think that's an option. Under this agreement, that's something that could happen. If you're entering into an agreement that's complicated and multifaceted like this, as we discussed earlier, this one says, you acknowledge again that we have advised you to have this agreement reviewed by an independent attorney of your selection prior to execution. By signing below, you acknowledge and warrant that you have done so. So, with respect to Todd's question earlier, the across-the-table exchange is not going to work so well. What makes a lawyer in a really good contingency fee case scared about telling the client, hey, take this fee agreement based on this big False Claims Act case and go talk to another attorney about it? Any input on that? Like,
Sign up with the other attorney?
Yeah, they could sign up with what if the other attorney says, I'll do it at 33%, not at 40%? Or the other attorney, there are all sorts of things that can happen if you put a nice claim in the hands of another attorney for review. But I do believe, as a lawyer and as a law firm, if you're entering into a complicated agreement like this that requires a lot of consent and a lot of advance disclosure to the client about what could happen, you're at risk if you don't tell them to go talk to a lawyer. In fact, you might be required to by the ethical rules.
Regarding the termination provision, what are your thoughts about the fact that it doesn't mention anything about the withdrawal being maybe contingent on the court awarding leave to withdraw? Because you have
that's a good question.
that approval from the court to do that.
So we've had situations. In fact, we were in a federal court action last year where it took well over a year to get out. The court kept coming up with more things it wanted done before it would allow withdrawal from a case. So and during that same time, motions were filed, had to be responded to, discovery was going, had to be taken care of, appearances in a foreign court had to take place. And so you can, as a lawyer, depending on the court, you can get stuck in the case and not actually get out. You could, I suppose, put a provision in that says, if we decide to withdraw because of your cause, client, but we're not able to, then you have to start paying us on an hourly basis. If you can do the same thing under the situation where, where if you just terminate the client without cause and get paid all your costs, why can't you also just turn it into an hourly assistant agreement, right? Any thoughts on that, Frank? You've been over there really scratching your head on a number of these things.
I was just thinking, as a practical matter, these things don't come up unless there's another lawyer around. And that's the only way I've gotten involved. And you put the lawyer that goes out puts a lien on the recovery. Mm-hmm. And then the new lawyer gets what he can. It's all over. The contingency fee contracts I've dealt with are really simple. but I can see where these things, should be addressed.
Yeah, and in a lot of our cases, there's some possibility, if you take a case on a contingency fee, that there's going to be an attorney's fees award. And so, like under 13611, does the law firm try to slice that off as an independent recovery from themselves? Or do they just take it as the gross amount of money that comes in from the lawsuit and split it with the client on a percentage basis? That would be a big issue that we could consider addressing. Yes, Julian.
Henry, if you had a provision that said, in the event that you withdraw without cause, that you would be entitled to your cost recovery plus a contingent fee, I think you might have an issue with whether that's a reasonable fee under the ethics rules of the state bar of Georgia.
Right, okay, so just to make sure the people on the video here, Julian has raised the issue that of a requirement in the state bar of Georgia rules that a lawyer shall charge only a reasonable fee. And that to me, these double recovery possibilities give rise to that issue, especially if you're getting what you would normally get times 2 plus 1.2 million, which would be essentially getting 4 times your normal hourly rate, 4 or 5 times your normal hourly rate at the end of the day. And he's saying that if you have a situation where if you just withdraw without cause and you get your costs back, and then later on you get your contingency fee.
You haven't really produced anything for the client at that point.
Yeah. Did you put anything on the table other than filing the complaint? That would be the argument. That's an analysis you would have to go through as to whether you will ultimately be seen by some body as being abusive of the client-attorney relationship. Here they basically say that if you do terminate us and there's successor counsel, you have to pay us on an hourly basis for everything you do. And then also, you've said you've reviewed it by an attorney. Talk about file retention, confidentiality. This is a provision I would actually like to see us put in our agreement. This on any agreement, including hourly, if the client has provided an email address to the firm, the client acknowledges that the email provided to us is secure, that the account belongs to that client, and that there will not be a waiver of the attorney-client privilege or breach of the duty of confidentiality if the firm send documents to or correspondence to that account. Now, once again, that's telling the client to go make legal determinations regarding whether there's going to be a waiver of the attorney-client privilege if I use this email address. But I actually oftentimes have a client set up a whole new email account with some reliable provider to actually do the litigation. Certainly don't use their work account. You don't want them to do that. If it's a personal matter, you don't want them to use their work account, email account, because then I don't know if it's privileged at all or subject to being attacked in any event. And also, you wonder whether you want them to use any sort of account, email address that the other side has known they've been using for a long time. That can lead to inadvertent problems of somebody typing in the wrong email address and it just squirting over to the other side inadvertently, or also could lead. Frankly, I think some email is somewhat easily penetrated, or they could subpoena the email provider, and then you have another fight on your hands. How many has ever just gotten a separate email address set up for just a lawsuit? I know I have. It's something to be worth considering. The other thing that happens is whether it's lawsuit related or whether they're trying to set up a golf game with you or whatever. If it comes from one address, they're trying to keep. Now, are they going to use that much discipline? I don't know. But you can do what you can do. But I think we ought to consider putting that in all of our engagement agreements. And then, of course, it ends on a happy note. We look forward to working with you. Hope it ends up being great. Please sign and send in immediately. So those are the issues I wanted to bring to your attention. Make you aware of False Claims Act cases. I went to several seminars this past weekend on that. It could be pretty nice if you get the right kind of case in the door. But of course, it could be a ton of work too. Any other discussion regarding contingency fee agreements and how they work and analyzing their provisions? All right, that's it. Oh, John's got it.
Henry, if somebody came to you and were dealing with the contingency fee lawyer and did want you to review this agreement, how much of this would you fight over? It seems to me it's egregious.
I would fight over a lot if it was me, because there are all sorts of places that adjustments can be made, such as preventing the double recovery of costs, possibly adjusting the percentage in a situation where there's also an opportunity for an attorney's fees award. Provisions in there, you could put provisions in that says you're going to try to collect from me. We had this provision up here where they separated out the ownership, for lack of a better description, of the gross recovery, and you say you're going to work just as hard trying to collect from me, the client, as you're going to try to collect for yourself, and that we'll only receive fees on we'll only do things on a pro rata basis. You get your percentage of the recovery in the same amount I get my percentage of the recovery. And then those would be areas. And then termination. You could really tighten up the termination provisions where you talk about what cause is. And it's only if I as the client am in breach of the agreement for like not showing up for depositions or something of that nature, that you can actually terminate me for cause and then make me pay all these fees to you.
Generally speaking, you don't have to advise a client to have another lawyer review a contingency fee agreement before the client signs it.
Anybody? I actually haven't looked at the rules on that. I'm not aware of that being the case in a normal contingency fee, and I presume it's not, because you have to assume that 99% of the time it doesn't happen, and that a lot of people would have been getting into trouble if that was the case. But rarely are they this complicated.
It's simple, and the only thing that was generally an argument about was, when do you take your cut out?
Mm-hmm.
And they want you to take your cut after you pay the cost. So you got to clearly define your cut is coming out of the gross.
Right.
Then they get their remaining amount and they pay all the numbers.
Right. So, but then the other question is, well, I guess there's the when does the cost come out issue, and then there's the what happens if you lose issue. Do they actually pay you the costs?
So they're supposed to.
And they're supposed to. And can a lawyer say, such as you might hear on TV, you don't have to pay a dime if we don't win for you? Can they say that? And if not, and can they say that at the table as they're signing an agreement? Sort of like, oh, I see it says that, but don't worry about that. We've never gone to collect against any client.
Isn't that unethical to advance the fees without an agreement that they'll pay it back?
Yes, and lawyers will argue that vigorously in order to get the client to sign the agreement saying they'll pay the cost at the end of the representation. But I have to believe at the same time they're also saying, but we don't worry, we've never gone after a client for that. But, you know, there's always a first time, right? In this one, it actually says, but you may be possibly ordered to pay the other side's attorney's fees and costs. And that is a possibility that, again, a client has no ability to assess. If they're being sold, you ought to bring this lawsuit by one law firm. Even if you go to another law firm, how are they going to be able to assess without looking at everything that the plaintiff's law firm has looked at, whether the case that's being brought might be frivolous and you might have to pay the other side's costs, which is a big issue. So if you're wealthy and you're signing up for a contingency fee agreement, you better be careful if you got provisions like this. If you're destitute, you're not worried about it as much because nobody's ever going to bother to go after you. So it is something to worry about. And if you're destitute, how are you going to go get a lawyer to help you negotiate your contingency fee agreement? All sorts of interesting practical problems. Anything further? Okay, well, thank you very much.
Thank you.
Y'all come back next month for Litigation Fundamentals with Henry Quillian.